Доброго ранку, шановні.
Good afternoon, dear ladies and gentlemen. Ukraine Crisis Media Center starts its work. The topic of press conference. This press conference is called for the first time. Ukrainian woman has won a domestic violence case in the European Court of Human Rights. Our speakers are Ann-Katrin, Zapryanova, IREX Europe, Karbovska, Ukrainian Women's Fund, Natalia Bukhta, advocate, lawyer, representative of Iryna Levchuk, and graduate of the training program of IREX Fund program. Also, Khrystyna, lawyer and head of association of JurFem. Maryna, Lehenka, Vice President, Strada, Ukraine. As you may know, on the 3rd of September 2020, European Court on Human Rights made public decision of the court in case of Iryna Levchuk versus Ukraine. And before, Ukrainian women didn't get such victories. So we will speak about this case, how this president may change the situation, and we will hear from those who participated in the case. The case of Iryna Levchuk came to the court, to ECHR, because our lawyers, female lawyers, underwent a program provided by IREX program, and also representatives of Russia and Moldova and Georgia participated. The program was coordinated by Ann-Katrin Zapryanova. Now we give the floor to her, and she is via Skype with us. Please, you're welcome.
Hello. Is it my turn to speak?
Так, ми вас дуже добре чуємо. Запрошуємо вас до...
We can hear you, please. Continue.
Thank you very much. Good morning, everyone, and thank you very much for having me with you today. Let me first say that I'm very happy and proud to see only strong women on the stage today. In order to contextualize my intervention and the project we were implementing with Ukrainian Women's Fund, I would like to start with a brief presentation of our NGO IREX Europe, an organization for which I work as project manager since 2015. IREX Europe is an international organization based in France and created in 2004. The main objective of our organization is to promote human rights and fundamental freedoms, and we do this mainly by strengthening the capacities of our local partners and beneficiaries. So our strategy is not to set up local offices, but to work in cooperation with local NGOs, as they are the most relevant actors in our view to work in their countries. And this is also an effort to contribute to develop their capacities. So in this framework, we include in all our projects some capacity development activities of our local target groups, so that they are able to increase their knowledge and better tools to promote human rights at local level. However, we are conscious that tangible change can only be done through changes in policies or legislation. Therefore, we include always in our action some advocacy capacity building or financial support allowing local activists to implement advocacy campaigns with the final objective to lead in changes in policies or legislation. Back in 2017, we had the opportunity to develop a regional project supporting women's rights in the Eastern Partnership countries of the European Union. We knew that we had to include activities likely to conduct to tangible results in the legislative field, in addition to the activities building the leadership skills of women human rights defenders. So we discussed a lot with Ukrainian Women's Fund, our partner in Ukraine, and we included in our project a project component targeting lawyers working on women's rights. We decided to focus on the European Court of Human Rights because, as you know, it's the only institution with the power to induce changes in national legislation in our target countries or encourage improvement of women's rights through judging a state for the non-respect of those rights. We based the project plan on our previous experience in this field because we already successfully trained lawyers on media law and on the European Court of Human Rights mechanism in another previous EU-funded project. With the support of this project that we implemented with Ukrainian Women's Fund from 2018 until February this year, lawyers working for women's rights in the region were offered training by highly experienced human rights lawyers. This included practical guidance on taking cases to the European Court of Human Rights or providing third parties interventions. The process began with in-country training on national law and exhausting domestic human rights remedies. Then, the second part of the training took place in Strasbourg, where the European Court of Human Rights is based, and included a tour of the court and participation in a court hearing. For us, this was a very important aspect, allowing lawyers to experience the court operation. The project was implemented in 5 countries, including Ukraine, Moldova, Georgia, etc. And the lawyers also had the opportunity to exchange their experience and challenges during our Strasbourg training. Then our project included individual mentoring by experienced lawyers to help our targeted lawyers to work on their specific case. Our project ended in February this year, but we have already reached successful results, as you know. All lawyers participated in our project declared that their level of knowledge in questions relating to making application to the European Court have increased. By the end of this regional project, a total of 9 applications were successfully submitted to the court in the 5 target countries. We had an external evaluator of the project, and she noted that the application to the European Court were supported by mentors in a way that was highly assessed by the participant lawyers. And the application also focused on a broad spectrum of issues, for instance, HIV status, custody issues, and domestic violence. At this day, the only decision made by the court concerned the case that we'll discuss today. This case, Levchuk versus Ukraine, is a great achievement for women's rights and for Ukraine, and it confirms to all of us that we have to pursue our efforts toward this direction. Thank you very much.
Дякуємо, пані Анн-Катрін.
Thank you, Ann-Katrin. Please stay with us in order to hear our further discussion and maybe to answer some questions of journalists if we have them at the end of the conference. So we are going to the next speaker, but first I would like to say that Ukrainian Women's Fund is the regional partner of IREX Europe, and they promote women's rights and support women. And now I would like to give the floor to the representative of Ukrainian Women's Fund. Good afternoon, dear ladies and gentlemen. And You know that the story of Iryna Levchuk and her lawyer, Natalia Bukhta, this is not just a story how Ukrainian woman won for the first time in ECHR concerning domestic violence case. This is a story about how one victory can change the whole systems. And I believe that this is really important because now all the courts of different instances in Ukraine should use this decision of the European Court when they consider such cases concerning domestic violence. We cannot idealize the situation. Judiciary in Ukraine is bureaucratic. And people with their stereotypes work there. It is difficult to change the system. But it is a pleasure that in Ukraine we have many people, women, active initiative who work in these systems, who represent those systems, and they want to provide change in order to make the system better, in order to be more efficient. And I believe that today they're going to speak about it at this press conference. Also, the story of victory of Iryna Levchuk, for us, this is a story about the importance of training for lawyers, human rights defenders, because without knowledge, without experience, it is really difficult, practically impossible to win any cases in any court, especially in ECHR. And this component of our joint project with IREX Europe, this is training for lawyers, and Ann-Katrin mentioned this project, this component. So 5 lawyers underwent this training, and Natalia Bukhta is one of them. So this training for lawyers, for human rights defenders with mentor support, maybe one project is not enough. And here we have a big role of professional associations of lawyers, professional advocates associations, and association of judges in order to support their female colleagues. We know it is very difficult to win cases, and we have representatives of profile associations today. I am sure that this story is the story of solidarity and mutual support of women. Women from different countries, from France, from different countries of Europe, representatives of human rights defenders organizations, lawyers, judges. This is a story, and I'm sure you agree with me, it is impossible to fight alone. When it is a situation of domestic violence for a woman, it is very difficult. When you are in stress, when you have a big trauma, you are terrified, and you think that no one can help you. And NGOs are needed, colleagues, lawyers are needed, advocates, people who understand you, those who can help. So this is solidarity. That is what we call this movement of solidarity. And we are really glad that this movement becomes bigger and bigger, and more professional women join us and help each other. Also, I believe that this victory will help tens of thousands of women in Ukraine who suffer from domestic violence. They should believe in their forces, they should not be afraid, they should address organizations, lawyers, and fight this injustice, fight for justice, actually. So we hope that we'll have more victories like this, both in domestic courts and in ECHR, and we hope that we'll have more and more claims like this. Now the floor will be given to Natalia Bukhta. She is a representative of Iryna Levchuk. Good afternoon. So I believe our today's conversation have different angles. So this is about the decision taken by ECHR, but I believe that today we should not speak about the text, because this text can be found on the site of ECHR as of 3rd of September, you may find this text there. So I would like to speak about my client, about her character, and why this case is so important for Ukrainian society. First, Iryna Levchuk is a mother. She has 4 children, and she protected her children. She has done it in different ways. She addressed law enforcement bodies. She addressed the courts. Not always she was supported and heard. She suffered physical and psychological violence, and her children witnessed this. When she decided to go to ECHR, she believed that her story should become an example for others, in order to provide an example to prove that you should always fight. As of today, Iryna Levchuk won the case at the CHR, and she proved to Ukrainian women that you should not keep silence about this problem. You should speak about it. And the majority of women, they remain silent for some reason, or they do not believe in end result and do not address law enforcers. And this is the biggest mistake. As of today, this decision of ECHR, we believe, and I believe my colleagues will support me, it creates an algorithm of actions. A person, for people who face some situations. This tells people how to act, how to protect yourself. Also, as of today, we may say that this case was considered for 1 year by the court, and this was not in vain. She had small child support for children, 3 of them from this man who violated her rights. She had big indebtedness in child support and didn't have her own housing. And then we increased child support and decreased areas in child support, and also privatized 5/6 of this flat, and 1/6 was gotten by her husband, former husband. And I asked, would you make the same step if you didn't know that this result will be provided? And she said that she would do this, and she wants to create an NGO and unite women around her. This case of Iryna Levchuk will forever come to the history of ECHR as the first time when a Ukrainian woman won in such a case. And I hope that thousands of women will be encouraged to find this help and to fight for justice. So you should knock on the door, and then someone will open this door for you. Then. Now, Nadiya Stefaniv is given the floor. Good afternoon. Thank you. It's a pleasure for me to be at this press conference for many reasons. First and the main is that the decision of ECHR in this case, for us, this is a part of our national legislation. It will be used by courts when considering the cases in the courts of the first instance and in the courts of appeal and in cassation courts. In accordance with the law on implementation of the decisions of ECHR, this is a source of law, and we should refer to this case. And it should be used in the framework of our national legislation. After the adoption of the law of Ukraine that reinforced the responsibility for domestic violence, the use of these national norms for lawyers, this was new. And we wanted to have proper court practice that will help women to protect their rights in cases of domestic violence. This decision of ECHR It thoroughly analyzes our legislation and international standards and the practice of our national courts in cases concerning domestic violence. This will help us to go to the new level, of understanding by judges of such problems, and in order to help resolve such cases. This is not only about civil cases, this is also about cases and criminal proceedings, and those administrative cases, and legal relations in case the defendants, as it was noted by my colleagues, when the applicants suffer from psychological, physical violence, sexual violence. Such cases, unfortunately, and such systemic violations sometimes lead to some really unredeemable damages. And we hope that our association and all the judges who will increase their qualification, they will study provisions of this decision and legal positions of this decision. They will be more efficient in hearing such cases. And the revision of cases is done by the Great Chamber of the Supreme Court. And the participants of this case, in accordance with the law of Ukraine on implementation of decisions of the European Court, they may address to the Great Chamber with an application. Individually, they may do this, and this may be done in such a situation. Also, we should develop a new training course at the National School of Judges in order to teach judges new provisions, new realia, new challenges that appear before the judges in the first instance and in the instances of appeal. And we should provide the unity of practice. Once again, I would like to thank those women, those courageous women, those who really reached their aim in this case. Thank you. Now the floor is given to Khrystyna Kit. Good afternoon. The decision of the European Court of Human Rights on the case carried out by Ms. Bukhta is important for Ukraine concerning cases of domestic violence. This is a strategic case. Unfortunately, during many years, we didn't have such precedents, such decisions of the European Court concerning domestic violence. That's why there should be unity of practice, change of approaches. This is not only a responsibility of judges, but also of the whole judiciary, advocates, lawyers, who also should use such decisions and refer to them when they go to court, when they protect their clients. ECHR has several decisions concerning domestic violence cases. This is against Turkey, the Moldova case, legislation that we have, and in Moldova they had some legislation concerning restrictive orders, and if we analyze practice in Ukraine, it is diverse. There are several cases that we may consider as those that have grounds to appeal to ECHR concerning efficiency and in cases of domestic violence cases consideration. Natalia Bukhta is a wonderful example how we may help people in such cases. I believe that decision of the European Court, the most important motivation why you need to go to this European Court is the change of legislation that is possible based on the results of consideration of the case in such a court if our legislation is lacking. Also change of approaches to such cases. Often our colleagues, lawyers, sometimes they see that this is, for example, just a case of eviction or some issues with the property, and sometimes they do not understand why they should mention domestic violence in this case. But the practice shows that no matter what the right is protected, whether it is divorce, property cases, eviction, if a woman suffers from domestic violence, you should refer to this. This should be taken into account by the court, and the ECHR states this. So there's gender violence, domestic violence. There are different approaches in such a case. So these are not standard cases. There cannot be just one template for all. And our association, when we carry out training for our lawyers, we stress that these cases are strategically important because they are connected with discrimination against women, and also concerning, we consider different cases of the European Court concerning different countries, and the decisions of the court, they should be implemented in countries at domestic level, and the responsibility. Sometimes we speak that judges do not often use practice of ECHR, but we should ask ourselves as lawyers whether we refer to such practice, whether we analyze properly such a practice. Do we really pay attention to this practice of the European Court? So this practice is accessible, and we tried to include them in our materials concerning identification of gender cases and how to deal with such cases of gender-based violence. So this practice is available in Ukrainian now. Please use it. And when we got the decision versus Ukraine, there will be bigger attention to such cases, we hope. And in our lawyers' activity, we will continue this practice through the prism of the approaches of ECHR, and maybe also if in Ukraine the legislation is not efficient, then we will go to the European Court, and there are many examples like this, because legislation about domestic violence and the mechanism we have now, in the majority of cases, they are new. And now they are tested. There are many questions that need resolution, and we should pay attention to them. And now the situation about domestic violence in Ukraine. The floor is given to the next speaker, Maryna Lehenka. Good afternoon, dear ladies and gentlemen. Good afternoon, dear participants. I'm really glad to be here. The topic we discussed today is really difficult for society on the whole and for each person who suffered. Today we have a pleasant aspect. This decision is a key. It is really important, not only for Natalia and Iryna, of course. This is a really important decision for Ukrainian society. And as Khrystyna said, this decision is important for legal community, but also this decision, I believe, will become important in several other aspects I'm going to tell you about. It should be a catalyst of change in approach to domestic violence case. Especially it is important for the victims, those who suffered from domestic violence, because we have 100 calls to national hotline concerning domestic violence daily. So our women are not ready to act, to start proceedings. We do not have a magic wand. And when a woman understands that it is a long way legally and it takes time, it won't be easy, unfortunately they lose their wish to continue. So this decision is an illustration. You should move forward, you should not stop. So they should understand that they are responsible for their own destiny. They should go in a legal way, and this decision shows that this end goal is possible. So this is a great motivator for women who suffer from domestic violence. But for some reason, these women do not want to address because they cannot see themselves going along this way. These can be absolutely different reasons. Some negative experience of addressing bodies of power, or they do not trust in themselves, they are not supported. Unfortunately, there are many reasons like this. But this is an illustration. It shows that everything is possible. You should move systemically along this way and reach your goal. Also, I believe that this decision will be really important for the subjects that should respond to domestic violence cases. And today, it is an illustration concerning restraining orders, temporary restraining orders, because those who respond, those bodies, as of today, they believe that property rights are at the same level with the rights of the applicant. For the right of protection of your health and the health of her children. But this is not the case. And property rights of the perpetrator, they cannot be higher than non-property rights for protection of life and health, and for protection of children. When Strada, Ukraine, together with DCAF, carried out a survey, we had non-satisfying figures. It was revealed that 39% of police officers and prosecutors, they believe that domestic violence is a private case, and 30% of judges also believe so, that these issues should be resolved by the couple. So I believe that a moment of change came for the legal community and for all the subjects that should work in this area and that are working in this area. So we believe that this time has come. Thank you. Now we will have Q&A session from our viewers, from our journalists. Dear audience, please introduce yourself first. Vera, Ukraine TV channel. I would like to ask Natalia, a lawyer, about difficulties your client faced in Rivne. She addressed local law enforcers concerning domestic violence. She filed claims. Did they respond properly to her claims? And I know from the case that appeal and cassation courts, they sided with your husband. And I would like to ask about the attitude of these bodies concerning domestic violence. So she addressed law enforcement bodies. Her claims were accepted, but there was no proper response. Or some protocols were compiled, but the case was not sent to the court. and she doesn't know about legal cases, and they had reconciliation agreements. So this was during the period of her marriage. Then after her marriage, violence continued. They lived in the same flat. She repeatedly addressed law enforcement bodies. As of today, we cannot comment why there was a delay on non-proper actions were taken. But this is about the first part of your question, about difficulties that she faced. She didn't know legal matters. She was legally illiterate, and she was trying to do everything she could. I was not a lawyer at the first stage. She addressed me and Ukrainian Women's Fund when she had 3 decisions of 3 instances, and she came to me when she was at the stage of going to the European Court of Human Rights. So I didn't participate in those court hearings. I worked with documents. In the first instance, he was evicted, her former husband. Then the Court of Appeal sided with her husband, and cassation court also sided with her husband, supported appeal. Yana for channel. I would like to ask Natalia Bukhta about your first meeting with Iryna and what focus did you have in this case? And are there any even small chances to win such a case in Ukraine? After decision of Iryna Levchuk in the ECHR, I believe that all Ukrainian women have better chances to get such decisions in Ukraine. So she addressed me together with the Ukrainian Women's Fund. We worked after training, and she addressed for consultation. She had 3 court decisions and separate documents in the case, and she addressed about what can be done at the national level. I worked with the documents, with court decisions, and I said that I believe nothing can be done at the national level. The only thing I say that you may go to ECHR, taking into account circumstances that were included in the decisions. And she didn't take this decision at once, but in some time we met again, and she was motivated. She wanted to show to Ukraine that she is fighting for her children, and her case should be an example for Ukrainian women. I explained to her that our chances are 50-50. So we didn't know whether the court will take positive decision, whether we will be able to explain to court what happened. So it was difficult for us to. So all the commissions in Rivne, they go to her house, they try to establish how she lives, how her children live. So the primary letter with proper stamps. Unfortunately, she didn't get the first letter, but we started to communicate with in that moment. 5th channel. Tell us, please, about the number of cases filed to ECHR concerning such type of cases. So this is the first victory. Can we say that now women and men may file to Ukrainian courts concerning the same cases, and they will be able to win cases, and there won't be any need to address the European court? So Iryna Levchuk's case is the first case in Ukraine, and the ECHR established violation of Article 8 of Convention on Human Rights. So the peculiarity of this case, this is not about only women. This is about both men and women, so any person may address. This also may be men. These may be children, the members of the family. As Nadiya said it correctly, if legal system will use efficiently this decision when they take their decision, if the lawyers will refer when they provide claims and other documents, if they use this judgment, this decision of the court, this will be easier to resolve such cases in Ukraine. Do you have other questions? The question from UCMC. So what was the decision? Or it is a consultative decision? Will she get some compensations? We need a concrete answer. What will she get in the result? So this is a final decision. It is obligatory for implementation in Ukraine and in accordance with the law concerning implementation of decisions of the European Court. So Ukraine in this case violated positive obligations concerning adherence to international convention, Article 8 of the European Convention. The violation was established and compensation is established that should be paid by the state. It is put in the judgment in accordance with the decision. The state should pay such a compensation. After this, the state should check and change its legislation. She is suffering domestic violence 2010, and she says that one of the officials say that there's nothing wrong, that her husband abuses her and strangles her. So what is the algorithm of actions for women who face such situations? Because many people now watch us. Maybe this will be an answer for many people. I will try to answer, and my colleagues will add, if need be. There are many cases when women address police, as Nadiya said and Maryna said about it. Strada carried out a survey on this. Often, police officers believe that these cases are minor. They wait for some heavy bodily harm, then they will respond. But the law says that in case of domestic violence, even if it is psychological violence without bodily harm, there is administrative responsibility. If it happens often, more than 2 times, even criminal responsibility is envisaged. That's why actions of law enforcement and their words that they allow themselves to say, this is not legal, this is discriminatory. If you file to police and police does not respond, write down the name of a person and you may complain to higher officials. Write your complaints. You may ask police to call police, ask them to come. You may go to police station, and you should do everything in writing. There should be then proper official response, and if it is not proper, then you may complain at higher instances. Also, you may search a lawyer in your region. On the JurFem site, there is information about lawyers from different regions. You may go find the map, find your oblast, and you may find a lawyer you may address to. You may write to us, and we will recommend to whom to address to. Also, I would like to add to what Khrystyna said, that women should be welcome at NGOs. There are many NGOs in different regions. For those women who suffer, they may help with finding those people who may provide legal and psychological help, and this is really important in such cases. They may provide advice and all the necessary information, and this happened with Iryna. And I believe that this experience shows that it is really important to address everywhere, especially to NGOs. You should not be afraid. You should not. You should not be afraid to continue, because sometimes women start, but then at some stage it takes a lot of time, it takes a lot of effort, and often women do not want, they just surrender, they cannot move forward. And I advise to you to move forward, not to be afraid. I would like to add that each case is unique. And domestic violence is not the same. Each case is individual. So standard algorithm, it is difficult to create. Specialists should help a person who suffered an algorithm that will be appropriate to an individual case. As Natalia mentioned, you should address to NGOs, you should address to organizations established by law. This is a large spectrum of organizations. I won't mention all of them. This would take a lot of time. In each case, there are organizations that can help. If domestic violence happens, you should address police. If there is a threat to your health or life, you should call 102. So you should not be afraid. This is a situation that is regulated by law. You should address police. Also, I would like to add that Strada Ukrainian show has a hotline to counteract domestic violence, gender discrimination, human trafficking. This is 24-hour hotline. There is a lawyer. You may call this hotline, and you may create your own algorithm. You will understand where to move. So this line is 116123. You may call it 24 hours a day from all operators. And also you may address for secondary legal help all those who suffer domestic violence, independent of their sex, independent of property status. All the people are provided by secondary legal help. So you should use this right. Thank you. Our audience now become more active. So one more question from our audience. Those who watch us through Facebook, they ask whether there were court hearings concerning economic violence, and do they use domestic violence legislation in such cases? Court consideration of economic violence. I believe there were no such decisions, but economic violence is in complex with psychological violence, and the decisions of the court concerning such a type of violence as economic violence, I believe in the future we will have a lot of such decisions, but often they address with the complex of different types of violence. Also, I would like to say that about 2 years ago, the police had an experimental training called Polina, and police officers were trained how to act, how to record the cases of domestic violence. That's why you should not be afraid. You should address police to record all the cases. Only police officer may take this, may provide this restraining order, and also only police officers may do it quickly when women need this help fast. And then court hearings will take place. This will take time when there will be we know that restraining measures were used in this case as well. So also you may address legal help in order to elaborate the tactics of your action. And of course, you should first address police. So we are coming to an end. So maybe you will tell something inspiring to those who suffer from domestic violence, those people who think how to protect their rights. Let's start with Ann-Katrin. She is with us, and she was listening to our discussion. You're given the floor, please.
Thank you. Yes, what I would say is that you are not alone. You see here that there are some people fighting for you as well. So if ever you need support, don't ever lose faith and continue fighting for your rights, and you will not be alone. Somebody will help you. There are a lot of strong women around in your country that can help you.
Дякуємо, шановні спікерки, хто бажаючи.
Would you like to say some final words, final remarks? Let me continue. So, Ann-Katrin said it just greatly. There are always people who are ready to help. And I would like to go back to Moldova and Ukraine cases. I do not know statistics, maybe my colleagues know this. But I know the trends. I know that from Moldova there are many more cases. And this country is much smaller than our country, and they have more cases in ECHR concerning domestic violence cases. And I have a question, why? And I hope that we may put, we hope that women after this case will be more courageous and will address the court, and our lawyers will help them. And we hope that our judiciary system will change for the better. I would like to say that I hope that women will be able to use domestic system, that there will be no need to address the European Court. We hope that our system will change in such a way, because ECHR helped us to change, and maybe there will be less cases to the European Court, and we hope that the practice of domestic courts will be unified and will provide protection of victims and children who are witnesses of such cases, and they should be also protected. This is also very important. Thank you. So Iryna Levchuk, for her it was really difficult because she was the first one. After this case, the situation in the country changed, and we have a legal act that identifies domestic violence and people who suffer from domestic violence. And Iryna proved domestic violence before the 1st of January, and it was difficult for her because there was no proper legislation. And in the text of the decision, the European Court mentioned that there was a special act, but it could not be used at that time. That's why those women who will protect their rights, for them, after Iryna's case, for them it will be easier, and preventive function will be positive for Ukrainian society, because it is easier to prevent the problem than to resolve the problem. So I would like to call on the lawyers and legal community. First, I want to say is that we should get united. We should create circles of lawyers and human rights defenders. We should see our activity broader, not just considering individual cases. We should influence practices, approaches, and we should take into account human rights protection in our activity. This is the main. Thank you. And I would like to add and call on victims and subjects that should respond about victims. The main is not to keep silence. The situation won't resolve itself. Each time, every time, there may be deterioration of the situation. Please do not keep silence. There are many organizations, NGOs, who are ready to help those who are ready to support you. And about the subjects that should respond to domestic violence cases, starting police, prosecutor's office, courts, representatives of the social sector. Here we should understand that each victim, despite complexity of the case, is a victim in the case, and for them, their own case is really hard. We should understand that for each victim, her case is really difficult. You should respond properly in order not to go then to the European Court. This is an efficient measure to go there, but it is desirable that the case should be properly dealt with at a national level by proper bodies. Thank you very much for being with us in the press hall, and for those who watch us online, we thank you for your work. So this is the end of press conference. Have a wonderful day. Till the next time. Goodbye.